So let's move on to what we're really here about. Your Honor, I want to talk about what Brady v. Maryland actually says. Material is exculpatory Brady material if it is actually material in nature, relevant to guilt or punishment, favorable to the accused, and within the state's actual or constructive possession. Material evidence is evidence that there is a reasonable probability that, had the evidence been disclosed to the defense, the result of the proceeding would have been different. Here is why the credibility of this particular witness is material, Your Honor. In the sentencing hearing, and I'm reading from page 63 of the transcript that was prepared in this case, the court says, I do find, based upon the preponderance of the evidence that I've heard, that this defendant on other occasions has committed speeding. Ms. Mateen has testified a couple of times about this. It doesn't have to be criminal convictions. I find her evidence to be credible that he sped on other occasions. So her credibility is material, Your Honor. The next issue, relevant to guilt or punishment. It's what it says in Brady v. Maryland that has been the law since 1963. Her testimony regarding speeding became extremely relevant to my client's punishment because it appears to be the basis for an enhancement factor that was applied and led my client to get the maximum possible sentence absent consecutive sentencing. Favorable to the accused. Now, the state's position on this is none of this evidence was favorable to the accused because it wouldn't have been admissible anyway. Your Honor, that's not the standard. The prosecution's duty to disclose exculpatory evidence is not limited in scope to competent evidence or admissible evidence. The duty extends to favorable information unknown to the accused. You can cite that, Your Honor, to State v. Marshall, 845 Southwest 2nd, 228, Court of Criminal Appeals, 1992, which cited U.S. v. Gleason, 265 F. Sup, 880, a 1967 case. Admissibility is not the determining factor as to whether or not something is exculpatory. Period. Finally, within the state's possession, I don't think we have an argument about that. The reason this motion was filed, Your Honor, is because I have a duty and an obligation to make sure that my client receives not only the fairest trial, but due process of the law at all stages of the trial. That includes sentencing. The enhancement factor that was found by this court was based on prior testimony of speeding, and that witness's credibility should be allowed to be tested. What we're asking the court to do is to consider whether the credibility of that witness was properly tested in the absence of significant information that was not provided to the defense. I'm not going to go through the details of those events again, Your Honor. They're stated in my brief. The state responded in its brief. I will say that there are witnesses to both events who would contradict the state's version of events. Particularly, it was the state's position that the victims did not appear in court for the second arrest. We know that's not true, Your Honor, because one of those victims was in court right down the hall. That victim walked out that day with an order to have an ankle monitoring device. He was in court on April 23rd. I have evidence of that, Your Honor, that I will offer as an exhibit. This would be the page, the CJIS page showing he was in court that day, as well as the judgment document that I would mark as exhibit, collective exhibit number, well, okay, collective, or exhibit 1 and 2.
It's one exhibit then.
Collective
That's
exhibit.
Exhibit 1 to the Rule 35 motion here.
What we want, Your Honor, simply to ensure that all enhancement factors and mitigating factors were considered properly before sentence is imposed on my client. That's what we're asking the court to consider.
Well, Ms. Gunn, let me ask you this. If you had this information, how would you have used it?
I will say this, particularly with respect to the first event. I think that both of these events establish, Your Honor, that perhaps Ms. Mateen does not respond accordingly when presented with an adverse situation. It was Ms. Mateen's testimony at the February 5th hearing that she saw my client speeding, and so she called numerous times, and she was calling all of these different places. Now, there's no record of that actually happening. That was her testimony. The conduct in the other cases suggests, Your Honor, that perhaps her response is disproportionate to the event observed. I think that's highly relevant when considering the credibility of speeding events that she allegedly observed. That's how I would have used that information, Your Honor.
And of course, actually, her original complaints were made prior to the accident itself, wasn't it?
Correct. That was her testimony, Your Honor.
And I think there was some testimony that the complaints were received by the school.
There was one complaint received by the school, Your Honor, which I would gladly submit to this court. It was actually a note wherein she complained about them telling her children to cut the hoods off their sweatshirts, and then made a note at the bottom about the bus bouncing. That is the only recorded complaint that I have ever seen.
But as you indicated, based upon the fact that what that hearing was for, there was no basis to cross-examine or test her.
There really wasn't, Your Honor, and I did not know that she was going to be a witness on that issue, and I wouldn't have found that theft conviction anyway, because it was under the name Jasmine Brown, and I've always known her as Miss Mateen. So I would not have found that conviction to even cross-examine her with it at that time.
Anything else?
The only other thing, Your Honor, I did file a motion for my client to remain on bond pending appeal. His appearance bond has been submitted to the Court of Criminal Appeals at this time.
And let me move on that quickly. That, of course, came up a couple of weeks ago when the case was originally set, and the court would have moved on it then. I'm not sure, quite frankly, that the court has any power other than to say the Court of Appeals has the power by motion of either side to reduce or raise the bond. I would say in regard to bond, the law does say that based upon all the circumstances, a defendant can stay on bond pending the appeal. I would think with the 4-year sentence, and I think the record shows that he's served about a year of that already, has he not?
Correct, Your Honor.
And it's a substantial bond based upon the convictions. I probably would not have raised it, but I think the only one that has the power to do that would be the Court of Appeals.
And, Your Honor, for the record, he is still on his ankle monitoring.
And
So
I think that should continue. I think everything that was originally ordered should stay in effect. Mr. Dixon, I'll hear you then in regard to Rule 35 motion. Or if you want to be heard in regard to bond, I'll be hearing you on that. But I think it's probably too late, but I think it probably would stay the same.
Yes, Your Honor. Just briefly, we filed our response.
I did.
It's the state's quite troubled by the allegations that were put forth in the motion to reduce the sentence. These apparently Ms. Dunn thinks she's the district attorney and can determine what cases are prosecuted and which ones aren't. And she stated a number of things that aren't correct. The second arrest of Ms. Mateen, she was represented by Mr. John Cavett. The case was first up in March, and the case had to be reset because the victim was a no-show. And the alleged victim was a no-show again, whether he had court in some other courtroom or did whatever. He never appeared on that particular case. And so he communicated his desire not to go forward with the prosecution. And she had alibi evidence that Mr. Cavett submitted to the district attorney's office. The first recall warrant, somehow the magistrate's office thinks that only sessions judges can recall warrants. I'm not sure where that misguidance comes from, but obviously it's not true. It was informed that there was no corroborating evidence of the allegations in the first arrest, and was also further notified that the city police department, the sheriff's office, and the school board were working with Ms. Mateen with whatever communication issues that may have existed. and I think they work to improve those. And so it's troubling, and we also have an ethical responsibility if probable cause doesn't support a case, we're not to go forward. But apparently defense thinks otherwise. And as to the fact that she couldn't have found the theft conviction is not true. It doesn't take much of a search to find out that she has an alias. Ms. Dunn had a private investigator throughout the entirety of this case. She could have easily found that Ms. Mateen had been convicted of theft and could have cross-examined her about with that in the February hearing. And it's also noteworthy in the February hearing, that was before either of these arrests occurred, so she wouldn't have had an opportunity to cross-examine her about those anyway. And so essentially it's allegations against the DA's office and Ms. Mateen for things that aren't true and the facts don't support. And there are some other troubling things, Your Honor. As far as when we got the motion, Mr. Peterson could not have went down to the clerk's office and got a motion because his email to us was before the motion was ever filed. So there would have been no way he could have gotten a copy before that motion had been filed. And then the other problem that will be investigated is the fact that members of the apparently of the bar, officers of the court, who all have a duty to each court, to the state, to the Constitution, to uphold the law, somehow saw fit to expunged information, and the statute does apply to any and those who may have done that. And as I said, it will be investigated, and the request for that investigation has already occurred. And so I'm just at a loss while we're arguing things that aren't true, and then we're exposing expunged information. And if the right to know still has something up for Ms. Mateen, then that's not right either. It doesn't, just because that information is there doesn't mean we can ignore or eschew the law just because we want to cast someone in a negative light. And the exhibits A and I think it was D or C, those are the orders of expungement exist, and that's a release of that information violates the law. And if you note from Ms. Mateen's affidavit, she was about trying to get employed, and the employer specifically referred to the article, the May 12th article, and the allegations as the reason why she wasn't going to get hired. And as noted in our response, in the Tennessee Supreme Court's response to that, it's very clear why that statute exists. The intent of the legislature in enacting the statute at issue, in our opinion, was to prevent a citizen from bearing the stigma of having been charged with a criminal offense where he was acquitted of the charge or the prosecution was abandoned. It's common knowledge that preferment of charges against a citizen can have a severe impact upon his reputation. It's very clear, and in the release of this information did just what the court and the legislature wanted to avoid, a negative stigma upon someone. And so for a number of reasons, the motion should be denied, and the court has our response, and we will speak with the Attorney General's office about the bond issue. I think the court is right. It's now.
Would you agree? I don't think the court has jurisdiction.
I think the court's correct. Now, Ron.
And I think, and Ms. Dunn she did not file a motion for new trial, which normally is done, but she didn't have to. The law provides that.
That's right. That's right.
Researched that, and that normally comes up on the bond motion at the motion for new trial.
Our office will communicate with them in regard to the bond.
Well, Ms. Dunn, anything else, ma'am?
Your Honor, while I don't believe it's relevant to anything, I'll just refer to Mr. Peterson's email. I've been hearing that a motion is going to be filed today in the Johnthony Walker case. I don't know what it's going to say. He didn't have the motion. I don't do those sorts of things, Your Honor.
This initially, I don't know if it has anything to do with the court's ruling in regard to Rule 35, but our system is a good system. There's some flaws in it, but it works better if the defense and the state are represented by good, competent lawyers. Such has been the case here. The state was represented by good, competent lawyers. This defendant, Mr. Walker, has been represented by a good, competent lawyer. And that goes further to indicate that in many matters, the lawyers can cooperate to meet the ends of justice, not to do anything in violation of the state's rights or the defendant's rights. But I think the record shows that these parties these lawyers have done this. And I don't know that there's anything in front of us that shows that either party has violated those ethical standards. But both sides have been represented by good, competent, ethical lawyers, and I will say that for the record. And a couple of other things that need to be said. First, the state's filed a response about that Ms. Mateen was not used in the case in chief, but I do think the law in regard to exculpatory evidence, if it is in fact exculpatory, that not only applies to the case in chief, but it applies to sentencing as well. So if Brady versus Maryland, which we use to indicate that the defense should be given anything that would likely be of assistance in regard to sentencing or trial, should be submitted to the defense. And secondly, I think it's very clear that the district attorney in this county, the district attorney across the state, has the power to dismiss any case that he or she may see fit to dismiss. That power is solely, with a few minor exceptions, within the district attorney's office. And so the cases were dismissed for reasons that Mr. Kingston mentioned, and we will leave it at that. But let me say further that this Dungeon motion has filed and said this was exculpatory. The thing that bothers me about that is that Ms. Mateen's original complaint, which I found to be credible, was made in the fall before this accident happened. I say accident before this event happened, which resulted in the deaths of these children and the severe injuries to the other. It happened prior to that. And she testified prior to the trial and prior to these dismissals of whatever may happen in regard to other cases, that she had in fact made complaints to the school and different people about speeding. I will say this. I think the thing that caused this to happen was because of the excessive speed of this defendant. And I think speed was an issue at the trial. Speed was an issue at the sentencing. And the court did find that there was criminal behavior before the trial because the court found, based upon the proof that she had been involved, or that Mr. Walker had sped before this happened. Now, I will say this further, that the state did, the only reason that the state called Ms. Mateen at the sentencing hearing was as a victim of a crime. And, you know, it seems like to me if somebody's going to be a not a credible witness, somebody who has lost their child and somebody who has had another child or children severely injured, her credibility would be in great dispute, I suspect. But that's certainly no cross-examination in regard to that. But she had made complaints of speeding in the fall, and the only thing the state didn't call her, didn't ask her anything, the court asked her, did you not testify earlier that Mr. Walker was involved in speeding this bus with the kids on it? And she simply said yes. And you know, it's done, didn't cross-examine, and I don't fault her for that, quite frankly, but I did find that speeding, criminal behavior was involved in the fall. She made complaints at that time, and prior to anything else happening, she just confirmed that at the motion and limine hearing, which was before the trial and before these alleged two events occurred that were dismissed. So I don't think that evidence is material. I don't think it would change the outcome of the sentencing at all. The sentencing laws say this, that the punishment should be the least severe amount of punishment to achieve the ends of justice. I think anything less than 4 years to serve in the penitentiary for the event that occurred would not achieve the ends of justice. And I so found and spent a great deal of time in discussing the thing that I thought was difficult was whether Mr. Walker could be adjudged to be a dangerous offender, which meant that the cases would be stacked on top of each other, which would have resulted in a greatly enhanced punishment. I didn't think that Mr. Walker fit those guidelines, and so found. So I don't think the ends of justice would be met. I do find that there was evidence of speeding, but that was not the only enhancing factor that I found. I found that that a lot of people, a lot of parents, had turned their kids over to this bus driver on that date and earlier dates with trust. I think the trust is that a parent, when they put a 5 or 6 or 7-year-old child with a school driver, has trust that the school driver will not speed, will not do anything in violation of the law, that when they leave in the morning to go to school, they will arrive at school. When they leave in the afternoon from school, they will arrive safely at home. And the events that transacted in this November date would not have occurred. So I found two enhancing factors. Speeding was involved prior to this event, and I found credible evidence that a complaint was made. I don't think that Ms. Mateen could have been cross-examined at the sentencing hearing. That it was her testimony. This was, did you testify this earlier? Yes, that he was speeding. But what the state didn't put her on, that the court asked that to bring into focus that speed was important not only on the day this accident happened or this event happened, but that it had happened earlier than that. So I think I would agree it was done that expunging or exculpatory evidence does apply in sentencing, but I don't think in this case it would have been material to if that knowledge had been known. I don't think it would have changed the outcome. I don't think it would have achieved. It would have done anything. I think the justice, the least severe punishment was meted out that would achieve the ends of justice. The Rule 35 motion says that the courts, if you have a difference of opinion or if the court comes later and says, well, maybe I didn't consider these things appropriately, then Rule 35 allows the court for 120 days to change that. I don't find that to be the case. I find that the ends of justice, the least severe punishment was given to Mr. Walker to achieve the ends of justice for the act that he committed. Certainly, if you look at the things that occurred because of that act, then 4 years would be not enough at all. So, but I do think that achieved the ends of justice. The court spent a great deal of time in study and work and everything to try to do the right thing for the state of Tennessee and Johnthony Walker, and I think that was done. The sentencing is on appeal. I've indicated that I probably would have allowed the same bond anyway, but I think the bond was appropriate at that time, and the Court of Appeals could look at that bond, which is still for a 4-year sentence is appropriate. Motion, Rule 35 motion is overruled. And once again, that is an appealable thing that the defense may seek to appeal. Okay?
Can I have a request a copy of the transcript?
This year?
Yes.
Okay, this we'll provide that. Thank you, Ms. Dunn, and Mr. Kingston for your presentations today.
Thank you, Your Honor.
Yes, sir. Karen Love Taylor is here, page 3334.
It's here.
Yes, sir.
All right, well, if anyone else not come back since lawyers, anything to follow up before I call some of the motions that have been filed by individuals themselves?